who's the director of research for Federmann, has been is responsible for uploading the people. He had to attend a security matter, but now he's back with us. That sounds a bit dramatic. I see Ron, I see Tehilla. So thank you for joining. This is a meeting that we've decided to retain, notwithstanding the environmental conditions, which are indeed very difficult and troubling. The topic of our discussion doesn't bear directly on the security situation in this region, but of course, at some level, it may have to do with, application of standards and the degree to which and questions of accountability. So on that level, maybe some common threads could be identified throughout this discussion. I'm very pleased to have this opportunity to moderate this meeting. Those of you who are not speaking, please switch to mute so we don't get any unnecessary distractions. This roundtable is designed to allow us to, within the Federmann cybersecurity law program, have somewhat of a better understanding of an issue which is raising a lot of attention in Israel and outside Israel, and also has generated quite a controversy surrounding it, and it has to do with the development, exportation, and deployment of cyber defensive and offensive intelligence tools. I would suppose that this is a controversial topic on a number of levels, but perhaps three general aspects come into mind, which I think we would have to discuss throughout this panel at some level or the other. One is that the very notion of the application of intelligence tools, collection of information through cyberspace, is a very controversial tool. I mean, it has, of course, governments are in the business of collecting intelligence, but with digital tools, in cyberspace, their capacity has vastly increased, and that, of course, raises very significant privacy concerns as well as other rights concerns. And in a way, this raises serious issues about power and abuse of power, accountability, etc. Now, add to that another dimension, that when one is talking about cyber intelligence tools, one has to also take into account the role of private actors in developing, in marketing, sometimes in actually applying or monitoring the application of such tools. And that, of course, raises another layer of complexity, given what we know about difficulties in obtaining accountability for human rights, alleged human rights violations by businesses. So that's a second layer, the role of private companies in upholding human rights or in contributing to violations of human rights. And then we have a third element, and that is the cross-boundary element, and that is that we are dealing in such, when we are discussing such issues, certainly in the Israeli context, we are dealing also with export of technology, export of capacities, of services. And there goes another question of to what extent is a company based in country A responsible or accountable for violations that take place in country B, and what is the role of the territorial state in which the company operates, as well as other states involved. So we have the tool itself raises issues, the private nature of the business that develops it and implements it. And then there's the question of any export control. And we have to discuss this today. I mean, I'm sure other issues would arise, but for me, these are like the three main axes of the discussion. We did not plan to have this as a conference panel with structured lectures, but more in the sense of a conversation. We have assembled four very notable and knowledgeable speakers that can cover different aspects of the issue. I've sent them some questions to consider, and we will be having this discussion based on rounds of questions, responses, and then we will also leave some time for Q&A. The idea is really here to try to get to the bottom of things and to try to enrich our knowledge and understanding of these very delicate and difficult issues. The four speakers we have with us, I would briefly introduce them in the interest of time. I mean, Israelis know many of them, but I realize not all the audience is from Israel. Our first speaker or our first participant will be Daniel Reisner. Daniel is a partner with Herzog Neeman, which is one of Israel's leading law firms. Daniel is specializing within the law firm in handling cases relating to security and also public international law. He has a vast experience in this field. Before joining Herzog Neeman, Daniel served for many years in the IDF. And has headed the international law department within the IDF, in which he has worked extensively on issues relating both to the laws of war, but also he was heavily involved in peace negotiations with Israel's neighbors, including with the Palestinians. So this is the first speaker. The second speaker we have on this panel is Ron Shamir. Ron is a fellow at the Federmann Cybersecurity Research Center, but I think his claim to fame in this panel is that he has been involved very much from the technology side in many of these issues. Ron served for many years, more than 20 years, in the ISA, the Israeli Security Agency, and headed the technology division, and he has been involved after retiring from ISA. He's been involved in a number of cyber technology development project and enterprises, mainly in the healthcare sector, but also in the field of cybersecurity. So he is the second speaker. The third speaker is Shmuel Sunray, who is also has vast experience in working in the field of providing legal advice for security companies. Shmuel is now is the general counsel for NSO, which is of course a leading company working in the field of cyber intelligence. Before that, he worked with Rafael, which is another major Israeli arms technology, security technology manufacturer. And before that, the Israel Military Industries, which is another, of course, major player in this market. So he has a number of perspectives into lawyering of security technology companies. And our last but not least speaker is Tehilla Altshuler, who is my colleague both at the Federmann Cybersecurity Center, where she is a research fellow, but also at the Israel Democracy Institute, where she heads the Media Reform Program and Democracy in the Information Age program. Tehilla specializes both in media law, but also has a vast experience in law and technology, law and cyber, and has worked both on the media side of the industry, but also in the academic side of the field. So I would like to proceed, colleagues, straight on to the topic at hand. And the first question, which I ask you to briefly consider, is the question of the legal frameworks, trying to understand what are the legal goalposts, what is the legal framework which we should be thinking when we are thinking about the norms governing the development, exportation, and development of defensive or offensive cyber intelligence tools. Who are the addressees of these norms? And specifically, what is the role of Israel as an exporting and importing country in applying norms in this field. So maybe Daniel, you can have a first go.
Sure. Thank you very much, Yuval. And thank you for inviting me to this event. For full disclosure for the audience, in addition to my background, I also represent, I believe, almost every offensive cyber company in Israel. I advise all of them, including my friend Shmuel and NSO. So I have a relatively good picture of the market. The second comment I wanted to make is that I actually have an issue with the way you phrased the questions at the beginning of the presentation. Because the way you phrase the question, and it could indicate your perspective, which is totally legitimate, is that we have a problem. And I'm unsure if we have a problem. And I'll explain what I mean. The issue of balancing between national security and human rights is at the bedrock of our discussion. And while all of us recognize that human rights are important, we need to, at the same time, recognize that national security is also important. So when we say, or you say, that governments use tools to collect information and data, well, you're absolutely correct. And today in the digital age, they have much more power than they used to. You are absolutely correct. I still don't see that as the problem. The problem only becomes an issue if you say that they have too much power with respect to the right to privacy, because that is the other side of the equation. Now, I know I am biased because of my million years working for governments, etc., but I think that we need to realize that in the 21st century, in the day where all of us are carrying mobile computers on our bodies at every single moment in time, we gave up 80% of our right to privacy when we joined the digital age. Because unless you don't want to play in the digital universe, you have to understand that it comes with some really bad risks. And the risks I'm talking about are nothing to do with government collection. They're everything to do with abuse of this by bad people. And I think we will all know what types of bad people we're talking about. If you recognize that this is an inherent risk of the digital age, and we'll hear from Ron later because his entire career was around this world, then you need also to realize that governments and police forces have to have the capability to work in this field to counter these threats. So unless we are okay with the fact that people will come and use variety of software to lock your computer every day until you pay them $10,000 on a daily basis, if we don't want to live in that world, we need to start discussing the fact that some infringement on privacy is required in order to achieve a balance. Now, that is why, for me, the discussion was off to the wrong foot, because I don't accept that automatically the development of equipment which will enable governments to do this is automatically a problem. I think the question should be, A, is there any type of capability which should not be developed, just like we do in weapons? Other types of weapons we do not accept. So other types of capabilities we do not accept. For me, that is question number one. Question number two, if the answer is, put those aside, if we now focus on the ones which we accept could be legitimate, what should be, if any, the limitations that we impose, first of all, on their use? And when I say on their use, I mean their use by governments and police forces. Because I personally, knowing what these tools are capable of doing, am not a fan of giving them to people in the street. These are very powerful tools. These are exactly the tools that the bad guys are using to attack normal civilians and companies. So for me, that is the second question. And the third question is, are there any limitations we want to impose on the developers of those entities? And I'll give three very quick answers to them. First of all, with respect to tools which should not be allowed, I have already seen a few. I will just say that there are digital equivalents of weapons of mass destruction which exist. And they should be treated with the same care as you treat weapons of mass destruction. I won't go into the details, but let's just say that there is a very small subcategory of the digital world which should be looked at very carefully and possibly prohibited. If we put those aside and we look at what should be the limitations on the use of these systems by governments, let me start by saying that this is where international law comes in, Yuval. This is our playing field, right? We have the ICCPR, we have the Universal Declaration, we have national laws on privacy and human rights, etc. So every country has its own national security versus privacy balance, and we have our overarching international law balancing act. And I think we are in the middle of that, and I think it exists. And as a rule, I think it does a reasonable job of balancing. Now, some countries have decided to go further on the national agenda. And for example, the Europeans, the EU, has come out with a new framework on export of cyber surveillance capabilities, which is coming into effect next month. Now, this is totally legitimate. Some countries can say we want heightened review, we want heightened control over such tools, but what are they saying? We want heightened control to ensure that this goes to the right government. So where is the issue? That all of us understand that some governments are better than others. So the real question is, how do you control that this really important tool does not fall into the wrong hand? And this is where your third question comes into play, Yuval. And the third question, someone didn't mute. The third question is, today, in all of the Western world, these tools are controlled for export under export control laws. It's true in Israel, it's true in the United States, it's true in Europe, etc., etc. Now, when these governments decide when to approve export, today it's part of the decision-making process is to review the human rights record of the recipient government entity. And by the way, that is one of the focus of the new European regulation. So what we have is governments controlling where it goes to, only governments using these tools. Those governments are subject to the very complicated balance between national security and privacy, which is the basis of the balance in general in international law and in national law. And I'm not saying it works perfectly because each government will implement it differently. But as a framework, I think we're in the right place. So I will stop here, Yuval, because I know what I said may seem controversial, and I let other people shout at me.
Yes, I have a lot to say myself, but I will keep my role as a moderator for the time being and go to Ron now. Ron, maybe you can present your perspective on the question of whether there is a problem, what is the framework in which we operate, and what is Israel doing in order to regulate export.
The problem, that, as I see it, is in the fact that we have some kind of an arm race, which we can't really control. The problem begins in the fact that, as Daniel said, states develop cyber offensive tools, and I guess this is not in our scope here because we're talking about more the private sector. But the leaking of tools from governments, from technological units to the private sector is happening all the time, and we really don't have the tools to stop it because unlike developing a missile or a tank, when you talk about cyber weapon, you need only your laptop and what you have in your brain, and that's it. And you can register the company anywhere in the world, and there is no real way that the government can regulate you. So the problem, to my opinion, is the fact that we are in a cyber arm race, and it makes the whole ecosystem of the cyber going very fast in a way that make it very hard for the people or the companies that develop defensive tools to cope with the offensive tools that are out there. That's part of the reason so much of the offense economic, like ransomware or other things that are doing so well, and we're lagging behind with the offensive, with the defensive tools. So in my perspective, the technological problem is a big one, and we must remember that if you have a good offensive tool, you can do a lot of harm because you can attack in large scale. It's enough if you hurt or you take someone's data, or if you encrypt it and you want him to pay for ransomware. Either way, it's enough for the attacker if he has only 2 or 5% of success when he's doing a large scale of attack. And the fact that we see tools going from the security or the national level to the private sector is a big problem, to my opinion. The other thing is that the economic incentive here is huge. States and private sector companies also are willing to pay a lot of money for the offensive tools. It's a huge market. Tools are very expensive, and it's a big ecosystem of offensive tools. I must say, not from a legal perspective, but from a personal perspective, that I feel uncomfortable with that. I feel uncomfortable that our good guys that were trained in the best elite technological unit that Israel can offer are doing that for a living. I understand the huge economic incentive, but I much prefer if they could do the same career, but developing defensive but not offensive tools. So I'm afraid that as you were asking about the fact that you were asking about our ability to control this and what to do to control this. I'm afraid that there isn't much that we can do, and I want to suggest a different way to look at it, but I'll do that in a few minutes after we'll have the opinions of others.
Okay, thank you, Ron. So we go to Shmuel, and maybe Shmuel, you can also share with us. I mean, to what extent are you actually regulated? Do you operate under clear national and international regulation?
Okay. First of all, I just want to start off by saying that Daniel and Ron, which I agree every single word they did. Sorry, Daniel, but their discussion is relating also to, let's call it maybe unconventional cyber type of tools. And Daniel talked about international law constraints of maybe certain tools, which of course is big questions as far as laws of war as applying to cyber tools. Again, talking about NSO specifically, we're not in that arena. We're in the intelligence gathering tool provision to governments, right? So I think that we're a lot lower in the food chain than some of these other maybe more controversial type of issues, because basically, and I think Daniel said it very eloquently, that we are dealing with a type of tools that are really just a matter of catching up to the opponents or to the bad guys, as Ron mentioned, and balancing the national security side of our customers with the privacy issues of our customers. And again, we need to remember that we as a private company, we're not the ones who operate these tools. We're providing software. And as such, the question is where our regulatory framework needs to be structured, going back to Yuval's original question. So I think that Daniel maybe gave it very, one of the maybe answer is, of course, export control. We sell to governments, and I think we all agree, like that was said before, we need to ensure, we need to go and take responsibility, both on the national level and on the company level, to make sure that these tools do not fall into the wrong hands. Our export control authorities, ours, and of course other international ones, are very conscientious to that. I want to refer you to one of the recent district court opinions when there was an attack over granting certain export licenses to NSO, and the district court basically determined that the Israel Export Authority deals with these issues and deals with them correctly, and that's, I think, the number one protection on the regulatory side that needs to be strengthened or dealt with in a more coherent manner internationally. But I think that the second thing is more a matter of self-regulation, which is something that we have put into place, and I'd be happy to expand upon that later on, dealing with the ethical side. Ensuring as a company, beyond what the government is ensuring on the national front, ensuring as a company that the tools do not fall into the wrong players, not only private players, which of course we never sell to, but also to the right governments, and what is considered right governments and what are considered wrong governments, which is a very, there are no real rules, very determinated rules as far as which governments are bad players or potentially bad players and which are not. And what we really did is taking the other compliance regulatory matters, like everyone of us, I'm sure, is familiar with the different compliance best practices in other areas, whether in export control, whether in FCPA, UKBA, foreign bribery, whether in antitrust, and taking these rules and applying them also to the human right aspect, as far as ensuring, conducting the right due diligence on the potential customers, monitoring, training, investigating misuse, dealing with it, shutting off systems if there is misuse. These are all pillars of compliance, of self-regulatory, that I think that NSO is kind of a pioneer in implementing such a stringent compliance program in this area. And just a general statement, and we'll go back to it, of course, later, but going back to what you asked, Yuval, as far as having international regulatory type of control provision, we believe, and this is something that we're advocating for in different forums, that the type of compliance, it doesn't have to be exactly our compliance, but the type of compliance that we are putting into place as far as what type of controls private companies selling to governments, these type of tools with their potential needs to go and implement and put into place in order to ensure that there is minimal risk. You can never say there is no risk, but there's minimal risk of misuse, and that misuse is addressed in the proper way. We think this is something that should be recognized in the regulatory international arena, whether by law or whether by best practices and compliance. I don't know, but it's not out there, and we believe that it should be out there. So I think as an introduction that I'll stop here.
Okay, thank you, Shmuel. And we now move to Tehilla. Maybe you can, Tehilla, address the three aspects we've been discussing. What do you consider to be the root of the problem? How do you evaluate the existing regulatory framework? And what do you have to say on export control in the Israeli context?
טוב, אני מתנצלת מראש, אני אדבר בעברית, כי צריך להגיד לי מראש על דברים כאלה. האנגלית שלי מצוינת כידוע לכם, אבל יש פה המון מונחים משפטיים שצריך לחשוב גם על איך מתרגמים אותם, כמו צו הצופן, למשל. אז אני רוצה להציע פה כמה קואורדינטות לשיחה הזאת, כי באיזשהו אופן, אני חושבת, דניאל ושמואל מדברים כל אחד על עניין אחר, וכדאי כאילו להפריד בין הדברים. צריך, אני חושבת, להפריד בין טכנולוגיות תקיפה, טכנולוגיות הגנה וטכנולוגיות איסוף. הבעיה שלנו היום היא, עכשיו, ברור שטכנולוגיות תקיפה יש להם את העולם שלהם, דניאל דיבר עליו, יש דברים שצריך לאסור בכלל על הפיתוח, כמו נשק, יש דברים וכולי. טכנולוגיות הגנה, הרבה יותר קל לנו להכיל אותם בגלל הטבע ההגנתי שלהם. באמצע יש לנו משהו חדש שקוראים לו טכנולוגיות האיסוף. זה מה שדיבר עליו שמואל. We are doing intelligence, gathering information, surveillance information, face recognition, כל המקומות האלה, אלה דברים שצריך להתייחס אליהם באופן נפרד. למה צריך להתייחס אליהם באופן נפרד? כי הדו-שימושיות שלהם מאוד מאוד גבוהה. ואת הדבר הזה צריך לקחת בחשבון. מה שאנחנו יודעים שהוא בטוח נשק, קל לנו איתו. מה שאנחנו יודעים שהוא בטוח הגנה, גם קל לנו איתו. מה שהוא דו-שימושי, אנחנו בבעיה, וווסנר בעצם עוסקת בדיוק בהקשרים האלה של הדו-שימושיות. אז זה דבר ראשון שרציתי לשים פה על השולחן, שכדאי לשים עליו לב. הדבר השני שאני חושבת שצריך לשים עליו לב, והוא, אני מביאה אותו במרחבים אחרים שאני עוסקת בהם בעולמות של תפר בין משפט וטכנולוגיה. יש 3 מרחבים. מרחב ראשון זה באמת המרחב המשפטי לרוב של privacy. דניאל הזכיר את זה. השאלות האלה, כאילו מה המשמעות של הזכות לפרטיות, אני כמובן לא מסכימה עם כמעט כל מה שאמרת פה, להגיד ש80% מהפרטיות שלנו ויתרנו עליה, סותר לחלוטין את כל מה שקורה היום בתחום של חקיקת פרטיות בעולם, את ה-GDPR והתפיסה שהוא מבטא, את מה שרוצים לעשות בארצות הברית. זאת אומרת, להגיד שלא אכפת לנו מזה, נראה לי לא הגיוני, אבל עזבו, יש את הסיפור הזה של הפרטיות. אבל יש עוד 2 מרחבים אחרים שגם עליהם צריך לשים לב. אחד, זה השאלה האתית. השאלה של אתיקה של טכנולוגיה הופכת להיות נורא משמעותית היום בעולם. והיא משמעותית בעולם דווקא בגלל שטכנולוגיה מתקדמת יותר מהר מרגולציה. ואנחנו רואים חברות שאכפת להם מאוד מהעולם של אתיקה של טכנולוגיה, ואנחנו רואים כל מיני אופורטוניסטים אפילו מקימים חברות לעשות אודיטינג אתי לכל מיני מוצרי טכנולוגיה, ואנחנו רואים את מייקרוסופט מסרבת לתת כספים ל-AnyVision בגלל אותו קנה מידה אתי שהיא מאמצת לעצמה. אז אנחנו לא יכולים לדבר רק על הסיפור המשפטי של פרטיות, יש פה אלמנט חזק מאוד של אתיקה. והדבר השלישי שקיים, וגם אותו אני כאילו מייבט עכשיו מהעולם שאני מאוד מאוד עסוקה בו בשבועות האלה, שזה הסיפור של השיבושים בדאטה רפואי, בסדר? לא קשור לעולמות האלה, אבל אני רוצה לייבט את זה שנייה לכאן, כי פתאום זה עושה לי שכל. זה הסיפור של הכסף, של הרויאלטיז, של זכויות השימוש, רון, הזכיר פה קודם, אנשים מביאים פה ידע, שהוא ידע שנוצר בכסף ציבורי בישראל. אני רוצה להגיד פה שהדלת המסתובבת שמתרחשת בין מערכת הביטחון לבין הדירקטוריונים של החברות האלה, לא הייתה מביישת את מה שקרה באוצר בשנות ה-90, ושנעשו הרבה מאוד מהלכים כדי למנוע את הדבר הזה, חובות צינון למיניהם, ואיסורי ניגודי עניינים, ושינויים במשפט המנהלי, כדי לשים לדבר הזה אלה, וכל הדבר, כל העולם הזה של הדירקטוריונים של החברות האלה, שיושבים שם בכירי מערכת הביטחון לשעבר, רובם מהגרים דיגיטליים שבאמת לוקחים אותם בשביל השם שלהם, בלי שהם מבינים את ההקשרים שבתוכם הם פועלים. יש לי דוגמה אחת יפה לאיזה מאמר תגובה שפעם כתב בוקי נאה על משהו שאני כתבתי בגלובס, בדיוק בהקשר הזה, אבל יש הרבה מאוד כאלה, וכל זה מתרחש מאחורי מסך כבד של הסתרה. כי מה שאי אפשר היה לעשות באוצר בגלל חובות של חופש מידע ושקיפות, אפשר לעשות במשרד הביטחון. אז יש פה בעצם, כאילו הצעתי פה שני סוגים של טיפולוגיות. טיפולוגיה אחת בין הגנה להתקפה לאיסוף, וניסיון לשים את המקום הזה על האיסוף, תנסו לחשוב על הפער בין חוק הפיקוח, שהוא בעצם איזושהי יצירה חדשה משנת 2007 נדמה לי, משהו כזה, שזה כבר לא חקיקת חירום יותר והכל, ועל איך שהם בורחים בחזרה לצו הצופן כשמדובר בטכנולוגיות של איסוף. כמו שהיה עכשיו באמת אפי הוציאו איזו הבהרה על העניין הזה. אז זה דבר אחד, זאת הטיפולוגיה הראשונה, והטיפולוגיה השנייה באמת, אל תתעסקו רק בפרטיות, תלכו על החוק, על האתיקה, וגם על ההקשרים הכלכליים, הייתי אומרת, והציבוריים של ה-royalties ושל באיזה כסף משתמשים פה, ומה זה המעבר הבטוח והשבי הרגולטורי שיש במשרד הביטחון, והדירקטוריונים עם הלשעברים, וכל זה באמת בחוסר שקיפות. עד כאן.
Okay, thank you, Tehilla. So we have, just for those who are not following in Hebrew, there are a couple I see in the audience. So Tehilla spoke, I'm not going to translate, but I'm going to just say, Tehilla spoke about data collection as being a distinct category that should be referred to separately from weaponry or defensive tools, the role of ethics, which we're just actually coming to, and then the issue of the revolving door between those who regulate the technology and those who actually market the technology. So maybe we can build on what Tehilla just said about ethics and try to go back maybe now in reverse order. Shmuel, you started speaking before about a commitment to certain ethical standards. So maybe you can say a few words of how do you approach the issue, and then maybe Ron, Daniel, and Tehilla would want to react, and then we'll move to the next phase.
Sure. First of all, Adit, I want to say that as far as what Tehilla said, as far as the ethical considerations that these companies need to take upon themselves, I totally agree. I mean, we really believe that ethics is beyond law. It's a very major part of the culture of a company, the culture of the employees of the company, of the management. I'm happy to say that you're talking about revolving doors. At least in our company, there is no one in the board of directors or management that came from a regulatory overview or any of these technological companies. So you're probably relating to others. So I won't answer that specifically, but going back to the ethics of our company and the way that we see it, we believe that the ethics is a very integral part of the modus operandi of the company. The compliance that I alluded to before, and I can maybe say a few more words about it, is something that we really put into place for ethical reasons. We put into different committees, the ethics committee, which basically, I think Daniel is one of the founding fathers of such, and I just helped kind of enhance it since I came into the company. But the ethics committee of the company is something that I think for almost from the foundation of the company has been in place, looking at customer basis, not just on a legal export control basis. And I totally agree with Tehilla also that we're talking here about a different category, not offensive, not defensive, but gathering. And I think that I'm taking that into consideration. We put in the ethic program, which deals with our ethical commitment, our human rights commitment, and the processes we have in place are thorough due diligence on customers, the training of both customers and employees that deal with this, the contractual terms that go and ensure that the uses will be only for the right purposes, the monitoring of course, we don't operate the system, and we're not privy to any data that goes on in the operational system, but on the behavior of the customer when there are allegations of misuse that could come up through a whistleblower procedure that we have in place, or from a press report or from an NGO. We'd be investigated in full. We get full cooperation from the customer. A customer that does not cooperate, that itself is a reason to cut off the system. And if we believe that the customer has misused the system and has not done it on the ethical, and again, I'm also emphasizing here, they could be done legally, right? The customer might have the right warrants in place and the judicial orders, and under its law or international law, it feels comfortable. If we believe that ethically there has been a misuse of the system that doesn't go and comply with the international human rights standards that we put in as our ethical benchmark, we will cut off the system. And this isn't just theoretical. We have done this at least 4 times with paying customers that systems have been cut off for ethical reasons. And we have also missed out on opportunities of hundreds of millions of dollars that were not pursued due to ethical reasons. So I won't bore you with all of the committees we have in place on the management level and on the board level and the governance we have. But on the basic point, I think that what I'm trying to emphasize is that we totally are ethically driven. We think that's a very, very major part of the industry. We think that all other companies that deal with this similar type of technology should also go and be conscientious and put in such policies in place. And of course, the ultimate responsibility lies with the customer, but it is our responsibility to ensure that we sell to the right customers that will use it the right way, and if they do not, then they will not be able to use our systems. And just one point I wanted to make, because this came out before, as far as private players versus governments, it's important to know that our competitors, our main competitors around the world, aren't necessarily other companies dealing with this technology. There are more nefarious type of governments that are providing such technology to various countries without scruples and without ethical considerations and without any type of restrictions, and sometimes without considerations, as long as they be able to go and have their backdoors in place or get their buyback of the technology, et cetera, or the information. And I think that the more private players, responsible private players, not private players in general, but responsible private players will be strong in this market and will be able to go and dictate the ethical considerations to the right customers and make sure that the customers are signing off on that. It will be, I think, bettering the whole geopolitical side of things and having less hostile countries providing such tools to governments that don't have the ability to go and develop them on their own. So I'll stop here.
Okay, thank you, Shmuel. Ron, to you, you've indicated before that you have some reservations about basically, I think, about this industry, and maybe you can elaborate and also respond to the, to the point that, first, there are some ethical tools that are put in place, and secondly, if Israelis won't be engaged in this, other actors would be engaged in this market. So what's your take on this?
So as for ethics, I think you were asking, Yuval, if it has a role. I think it has a role. Is it effective? I'm not sure it is effective yet. I want to talk about ethics in the technological units, especially here in Israel, of course. And we must say that when in Israel, when you're 30 and you're a technological unit graduate and you didn't have a successful cyber exit by the age of 30, something is wrong. And when this is the norm, or when this is expectation, I think that maybe ethics is not the first thing in mind. So I think what we should do, and it's a good I think thing to do right now, is start educating people that work in technological unit about norms and ethics that is expected when you develop software. And things that you used to do when you work for the government or when you're dealing with the security of the state of Israel, and let's say for a moment that it's okay to develop offensive weapon, cyber weapon, when you do that, I'm not sure it's okay to do when you leave the service, and especially if you're not sure what will be the use of what you're developing. Let's take a quick example to emphasize that. For example, if I'm a researcher and I research for vulnerabilities in software, let's say that I found a vulnerability in Windows, okay? Now, back in the days when I was in the service, this is I think a powerful finding of mine that can be used to, I don't know, save the security of Israel, let's say, for a moment. But when I leave the service and I work for in the private sector, I have two things to do with this vulnerability that I found. I can call Microsoft and tell them that I found this vulnerability. I might gain something out of saying that, but what I'm sure I'm doing is that I'm making Windows much safer for all of us here and all of us around the world. And if a lot of people do that, Microsoft has better Windows and we're all much safer. I can use the same vulnerability to develop offensive tools and I guess gain much more money. I'm not sure, I'm not in that business. And I think that the ethics that I'm aiming to is that I hope that more and more people, officers in the technological units, that they will get the right ethical training, let's call it. When they leave the service, they will choose the first route. Well, they prefer to make our world much safer, our internet world much safer for all of us, rather than develop offensive tools. We're focusing on offensive tools. There are a whole huge industry of defense, which makes our world much safer. So people are doing wonderful work developing defense tools, but we're focusing here on offense tools, and I think that it's something that ethics can help us to make the way or to reduce the number of people that choose offensive as the way of making living.
Okay, Daniel, and I don't know whether Tehilla, you also want to respond. Daniel.
Yeah, and I have three separate comments. I want to address three issues which were raised by previous speakers in this context. The first, I want to address what Ron is saying, that we have a problem with people developing capabilities inside the government and then taking them outside and selling them for money. So let me start by saying that Israeli high-tech, a large percentage of it was based on this model. The fact that we are global leaders in high-tech is directly connected to the fact that we have a unit called 8200 and a few other units whose names and numbers I will not mention. And the graduates of those units established many of our leading high-tech companies. Now, it is legitimate to come to say that was true 20 years ago. We don't want that anymore. But there's also another hidden assumption in what Ron is saying, which I think I question. It is no longer true that the best capabilities exist in the government. There are specific areas in the cyber world where governments still have the edge. But these are just very specific areas, specific tools, specific capabilities. But the more general, and I'll take what Tehilla called the collection information world, in that, if we are talking about targeted collection from specific computers or phones, governments are way behind the private sector in most countries, because that capability has long ago passed to the private sector. By the way, in the past, governments thought they could also develop cell phones better than private companies. But Samsung and Apple make much better phones than any government will ever make. So the truth is, in many of these areas, governments used to have the best technology. It is no longer true. I will share with you one personal story on this. The government came to one of my clients, of course, no names, to buy some capabilities from the private client. And we agreed to give it to them almost for free. But what was our only concern? What Ron said, that the young people in the army would get access to these tools, would leave the army in a year or two and take those tools with them and transform them into capabilities. So the entire discussion was, how do we protect the private sector against the government stealing their capabilities? And this is a real issue today. So when we talk about ethics, I totally agree with Ron that Israel has not done enough to, I will say, police the taking of know-how from the government to the private sector. I fully agree. For about 20 years, this was intentional because it created a lot of growth. Today, many people think it's an issue. I think this is an area which should be better administrated. And training and ethics could be a strong element of that. But it is not true to claim that all the knowledge in the government that the private sector is stealing In some areas, it's exactly the other way around now. And that is also an ethical problem. But I want to move Yuval and Tehilla to the focus of the question. As Shmuel indicated, I helped set up NSO's ethics programs many years ago. I've done so for many other companies since. Now, I want to explain to you what setting up an ethics program for a company means. It means that irrespective of the licensing procedure that you need to go through with the government, which could be the Ministry of Defense or the Ministry of Economy or other ministries, depending on specific area, in addition to that, you run a separate subset of checks to decide if you want to go through with the deal. So you could get the license, be authorized to do the deal, and decide I don't want to touch it because it would be bad reputationally, because I'm scared that the client may abuse my product. There could be a million reasons why. And there are many companies in Israel, including in primarily in the defense and cyber world, which have set up such programs. However, I want to share with you some really interesting problems which arise when you do that. Problem number one, governments are very easily offended when you say to them, I won't sell to you. And you get this incredible dialogue where a government calls you up and says, we would like to buy X. And you say, I'm sorry, I can't sell to you. So they immediately assume it's a license problem. Then you have to explain, no, it's not a license problem. It didn't pass my ethics committee. You don't understand what that looks like. Governments don't take that very lightly. But even more surprising is a response I got from the Israeli government once. Once when we told them in a meeting that we won't sell to that customer in spite of the fact that we got a license, they became angry at us. And they said, how dare you make this determination when we approve this sale? And we explained to them, but we're doing it in order to avoid abuse. And they said, if you fear abuse, come to us with the information and we will tell you if to sell or not to sell. Do not make this call on your own. Now, none of this is important in the scheme of things. I am really supportive of setting up ethical structures for companies involved in technology which is liable for abuse. So I think it is really important, and there are some models out there. However, and this is where I think the dialogue could be very useful, it would be good to come up with some models which are public, which companies could look at and decide what works for them. Today in Israel, it's all word of mouth. Companies that we work with, we tell them what the different options are, we help set them up, etc., etc. But none of this is open source information. You can't open a book and look and find a program for how to set up an ethical structure for a company involved in cyber technology. And this is something where I think academia and researchers and experts could help us generate some public source information, which could help companies develop this independently of need of word of mouth. And the final comment I wanted to make is that, and I want to go back to the privacy issue. I think the main question which we need to look at, are we okay with governments having the capability to breach our privacy, and under what conditions? Because at the end of the day, Shmuel said it very clearly, NSO does not operate any system. Neither does any other of the Israeli companies in this sphere. They sell equipment to governments, just like other companies sell missiles to government. By the way, do you know why we're having this discussion about cyber technology and not about missiles which kill people? Because people are more concerned in some countries with privacy than other people dying. In other words, and I'll explain what I mean. When the Europeans care about GDPR, and Tehilla, you're absolutely correct, in Europe it's a Bible now, they care about their privacy, not other people's privacy. So what happens is, when the German government buys a new missile, no one is concerned it will fire the missile inside Germany. But there's a huge concern that it will use a cyber tool inside Germany, which is why the Germans are world leaders in this area of legislation. So the concern against cyber weapons comes exactly from the same concern about people of abuse of their rights. And on this, I want to share with you, I'm not against it, I'm for it, but I do not accept the fact that this is a global phenomenon. Unfortunately, I work globally. And I can tell you that Europe is one thing, America is another thing, Asia is totally different, Africa is even different again, and the Middle East is different as well. And therefore, to assume that there is some global standard that everyone is going towards, I wish that were true. It is not how the world really works.
Okay, Tehilla, do you want to come back on this, or should we move forward with other issues?
Just a quick comment that I wanted to make. When we talk about ethics, we need to talk about contexts of ethics. And we've mentioned the multiple uses and their applications, and the inability to use the claim that we sell technology but we are not responsible to the way people use it or governments use it. That's the first one. The second, as I mentioned before, was the I would say the fog between intelligence, surveillance, and attack. But another thing I wanted to put here on the table is the difference between I would say national security uses and internal policing. I think this is also something that we are not actually referring to right now. If you look at the new proposal for AI regulation of the European Union, you're going to see that, for example, governments and police cannot use facial recognition systems for internal law enforcement. And I think at this, on the same point, we should look at the ethical aspect here. One more thing I wanted to say about ethics is that ethics needs it needs some kind of either a regulatory threat or public pressure. It needs some kind of an incentive. Ethics doesn't occur otherwise, and this cannot, as I said before, happen in a world without transparency, when everything is under the table and behind the black curtain. And this is, again, something that we've seen in Israel, because now Daniel says, obviously, we're having all those kind of ethical boards and so on and so forth, but nobody knows about them anything, and it never reaches the public because everything is being so untransparent.
Okay, thank you. I want to speed up things a little bit so we also have some time to get some Q&A from participants. So the third and fourth questions, which I sent to you, I'm going to now deal with them collectively and in a very concise manner. So going back to the first issue, do we have a problem? So I would submit we do have a problem in at least at two levels. One, by giving very powerful tools to governments, you are creating a potential for abuse. I mean, this is, the Lord Acton thing about, power corrupts, absolute power corrupts absolutely. So maybe cyber tools are not absolute power, but they're significantly more power than governments had before to basically surveil their citizenry and other residents. And by the way, Daniel, I mean, people die as a result of surveillance. I mean, this is not just about, getting information about privacy. I mean, in certain contexts, this is used against people to kill them. So, I don't have any numbers how many people have met this fate as a result of cyber surveillance, but there are, of course, very famous stories about abuses. And secondly, the second area that we may have a problem, and this goes back to the way I presented this, and maybe I didn't emphasize this enough in my introduction, and I think this came out clearly now in Tehilla's intervention, is the veil of secrecy. I mean, we don't really know who is doing what and how, and therefore there's a serious question of how can you get any remedy. So if you're a victim of unjustified surveillance by a country to which tools were sold and they were not supposed to be sold because due diligence was not actually made, or information was given but no one acted promptly enough to shut down the system. So how can someone actually get a remedy? So the question is, what can we do better in terms of strengthening accountability and in providing remedies for people who actually have had their rights and sometimes their even their lives infringe as a result of malpractices in this field. So maybe Ron, you wanna have a first go, and then we'll go to Tehilla, Shmuel, and Daniel.
Yeah, sure. With your permission, and not according to questions, I would like to suggest or to question our way of thinking, and maybe suggest something a bit different. In many cases, the way that the attacker gets our data is not by using very sophisticated tools. In a matter of fact, in many cases, you can use just web browser and clicking in the URL line, the right commands, and you gain access to all kind of data. So I wonder if we should put our effort in regulation and legislation in trying to regulate the companies that develop offensive tools, or maybe we should be regulating better the people who develop software. And I'm looking at myself, though I'm not developing actively these days, but I feel part of the community of the people who develop software, and I think that we're not doing enough in regulating ourselves in the right standards of developing software and making the world much safer for the people who use this software. There are many reasons. Most of the reasons are economic, by the way. No economic incentive to develop better software or better systems, and without the incentive, we get poorly designed software in the security aspects, and we get a very easy, usually very easy system that we can very easily get the data out of. For example, let's take our I don't know, a webcam. Most webcams are poorly designed. I mean, from the security aspects, and that's the way we can easily exploit them and get access to the footage that they view. And I think that maybe a better way or a better or more effective way to get what we really want to get is to regulate better the people, the companies that develop the product that we are using. And we should make the economic incentive, because I think that without it, it would be very hard to achieve the goal that we want. But with the economic incentive, and that can be achieved by, I don't know, if we want to punish companies that develop poorly designed software, or in other ways. But and if we are willing to pay, we the customers are willing to pay for better designed product, I think we can gain a real achievements in protecting our privacy in a better way. So, and the effect is much broader in this way, rather than trying to find those. I think the numbers are not that big of companies that develop offensive tools. So I think that this might be an idea that we should try to think in depth and see the ways that in which we can achieve this goal. And it's like for example, in our car, yes, in these days, the seat belt is part of the car. You don't have a kind of an aftermarket to put in place the seat belt. You expect to get it with the car. In security, in cybersecurity, there is a big aftermarket and very little measures that we get with the product. Maybe we should change that. And if we get better secured product, part of the problem of our privacy will be solved.
Okay, thank you, Tehilla.
I think I've said most of what I wanted to say. The only thing I wanted to add here is the internal regulatory framework that is being deployed in Israel in terms of the supervision of technological or security technologies. I don't see any reason why we should use emergency regulations for that. There is legislation, and there's definitely the Reisner covenant, and I definitely would advise better transparency, as I said before, in these realms. That would be enough for now. And maybe just one more comment on what Ron has just said. The question of how to do or how to create, I would say, legal design AI products is a question that is being asked all over the AI industries, both, I would say, civilian and others. In this sense, I don't think it's, or we should concentrate only on security technology.
Okay, thank you, Shmuel, and then Daniel.
As far as remedies are concerned, first of all, the primary remedy or the primary responsibility is for the body that did the misuse, i.e. the customer, right? You have to remember, we as private players, we do have, and we take upon ourselves the ethical responsibilities as far as the linkage to human rights, but we're not the ones that are infringing human rights. And I think that the ultimate sanction that we put in place as far as not enabling a customer that we believe has misused the system to have access to the system or be able to continue misusing the system, I think that itself is a very progressive remedy that, I think that let's make sure that other companies live up to this standard before we start talking about remedies given by private companies to individuals. One point, as far as legislation, I agree with Tehilla. I think, where the legislation is in place, either via Wassenaar or other export control. As far as ethics needing some type of regulatory framework, I think NSO is a wonderful example of the fact that there is a robust ethical program, without any type of regulatory necessity. Nevertheless, in order to go and level the playing field, we do believe that there should be some type of policy in place. It could be either via OECD or through other export authorities, or as I think Daniel called, through the academic world, to put in some type of best practices. There is, the State Department came out with guidance as far as procedures and what they consider as best practice compliance for export control of cyber security or cyber intelligence tools under ITAR, BIS, etc. I think that that's a very good example. I think it's I think there's things that could be added to in such a program, but I think that such type of programs, if they would have international type of acceptance, notwithstanding what Daniel said about the different parts of the world and nuances and different mentalities, I do think that some type of general regime dealing with export control of these tools with the right compliance and ethics consideration is something that really should be implemented and put into place.
Okay, Daniel, briefly.
Yes. Your question is about remedies, and I assume your question is the victim of an abuse of a system, against whom should he or she get a remedy? So I agree with Shmuel entirely that the first course of action should be to make that person eligible to come back to whoever used the tool and say, you violated my rights. The question, however, which is hiding behind your question is, should we give such right also to go after the manufacturer of the equipment? Now, on this, I would like to say two things. I researched this issue globally, and we found 3 cases in the entire world where this had been attempted and all failed. Now, I say that because the current case, which Shmuel, of course, is dealing with, which is the famous Facebook versus NSO case, is very high profile, but it's a unique case, unique to the circumstances of that company and that relationship. And it is very difficult to learn from it on about a global phenomena. So the reality is that companies which manufacture cyber capabilities, doesn't matter now if they are defensive, offensive, surveillance, collection, it doesn't matter, globally today are not viewed as responsible for the abuse by their customers. Now, when can that change? Of course, if the company was intentionally or negligent and created a capability which it shouldn't have. And then I think the regular rules of manufacturer responsibility for manufacture could apply also in the cyber world. But that would be in a very limited part of the world, of the circumstances. I personally understand the need to provide remedy to people whose rights have been abused. I just don't recognize why there is a justification to treat the cyber industry different than any other manufacturer of anything. Now, car manufacturers, in certain circumstances, you can go straight to the car manufacturer. Weapons manufacturers, in very unique cases, you could go back to the weapon manufacturer. But there has to be a defect in manufacturing or an intentional negligence in order for you to be able to go that far back. In my opinion, the same logic should apply to the cyber world.
Okay, so now the final round, and again, briefly, and then we open it up for questions. So those of you who want to ask, just indicate so in the chat. So really building on the case against NSO, the Facebook NSO case, I think this is not a legal question, but I think there is certainly a general malaise surrounding the industry. And we've seen, I think, in recent weeks also the Signal clash against Celebrite, where they actually basically released, they invited the hacking into their programs. We know there is there are negative press stories surrounding the industry. So the question is what do you think is the future of this industry? Whether in the long run it's going to, it will survive, and maybe should it survive, given the propensity of these products, of some products. I'm not making any claim with regard to any specific product or specific company, but the propensity of this technology to end up in the hands of very nasty regimes. What is the future of this industry, which directly or indirectly maybe helps to this unfortunate outcome? So maybe we start again. We go in the reverse order: Daniel, Shmuel, Ron, and Tehilla, and then we open it for questions. Very, very briefly, please.
Sorry, I want to share with everyone a secret. It's not really a secret, but most people don't know.
We can't hear you, Daniel. You're on mute.
We hear you.
Can you hear me now?
Yeah, we could.
Yeah.
I'm
okay, everyone can hear me except you, Yuval. Shmuel, can you hear me? Yeah, okay. So I'll keep talking. So the secret I wanted to share with all of you is that there is what Ron called a Cold War, which is has been going on now for 25 years, I think, between the defense and offense in the cyber world, okay? Now, it is not a war which goes on in secret. It goes on all the time, but it is not hidden to the companies involved that there are companies on the other side who are developing capabilities to break their system. So if you think the Apples, Facebooks of the world don't understand that there are companies who are on the other side and are developing technologies to break into them, then you're mistaken. But I'll take it one step further. They like those companies because they solve a problem for them. If companies like the NSOs and others of the world did not exist, then those Apples, Facebooks, Signals of the world would need to talk directly to the national security agencies of the world and answer the question, will you give me a backdoor into your technology because of national security consideration? Because of the existence of these companies, all of those multinationals are exempt from that discussion except under extreme circumstances. And they like it that way. So one of the reasons why you won't see companies like Apple making a noise about the fact that most of the cyber companies attack their iPhones using iOS is because they are okay with it, because the next patch they will come up with will block them, and they will go through this cycle all the time. So the future, Yuval, to your question, remains as follows. We have a constant shift in capabilities, both in offense and in defense. Governments will always try to get the best offensive capability. In offense, Tehilla, I mean cyber surveillance and collection of information, not killing people. While the other side, and there are lots of other sides, criminal elements, terrorist elements, but also private individuals who like their privacy, will want to stop governments from seeing what they're doing. Now, I don't know of any way of stopping this cycle because it is running, but I will also share a secret with you. The offense is winning. It is much more difficult, and this is what Ron was talking about. It is much more difficult to stop an attack than to create an attack. And as a result of this, the way this is going, governments are continuously at a disadvantage against the bad guys who can ever more easily infiltrate government systems, private systems, etc. So if you want my opinion where this is going, Yuval, the final sentence, this is going to a situation where capabilities on both sides are going to go and become stronger, not weaker, because the threat levels to privacy and private information are going up and not down.
Okay, thank you, Shmuel.
I think your question is twofolded, right? Where is the industry going and where is the regulation going, or where's the industry going, considering the, as you said, litigation, regulation, et cetera. So as far as where the industry is going, as long as end-to-end encryption will continue to be used by terrorists, pedophiles, drug lords, and other bad players, this industry is crucial because it's really the only solution that's available out there to go and basically breach the encryption or breach the hiding of the bad players under encryption. As far as where's the regulatory world going, I think that I kind of talked about that a little bit before, but I think that the world should be going, at least I hope it will be going, into a more robust regulatory understanding, regulatory/ethics understanding of how this industry should be dealt with, in order to go and seed out the bad weeds. The players that do not go and abide to these rules should not be in the business, should not be able to go and export, develop, etc. And the players that act responsibly and put into place, good compliance, good ethics, etc., should have protection similarly to compliance, kind of like immunities that are given under FCPA or other type of equivalent type of regimes. I believe that that's where 10 years from now this industry will be, and I hope that the good players will prevail and the bad players will be thrown out.
Okay. Yes, Ron.
From the technological perspective, I think that it depends a lot of what will technology bring in 20 or 30 years from now. So as for the near future, I believe that the industry will keep on blooming because nothing will really stop it. And the technological reason for that is that we're using an internet infrastructure that was put in place by Tim Berners-Lee some 30 years ago. And when he did that, he didn't think about all the security threats that we'll see in 30 years. So the foundation of the internet isn't secure, which isn't the enabler for the industry that we are talking about for the an hour and a half now. So I think until we will make a major change in the way that the infrastructure of the internet works, we'll see the industry keep on blooming.
Okay, and Tehilla?
I'm not sure I'm that capable of talking about the industry itself. The only thing I wanted to say is that the whole, I would say, technology space is going to get more and more regulated in the coming years. It has to do with social media, it has to do with AI in other contexts, and it has to do with those technologies. But I just want to make clear so that this voice is going to be heard. The claim that we actually need to thank those companies for preventing the creation of backdoors seems to me like we need to thank social media for allowing movements such as the Arab Spring. And we know that they create they have some good sides to their operation, but we also are very much aware of the dangers that those companies kind of pose. As we talk about regulatory frameworks and the need to create those frameworks, I think the call should be for more digital literacy of decision makers. Because if I may quote Shalev Julio in one of our conversations about the issue, he said to me, I had to teach the people at the Ministry of Defense of Israel what exactly I'm selling and how exactly they need to classify my technology in order to create this kind of a regulatory framework. And for me, that was a mind-changing quote, because I understood that regulators don't really understand, I would say deeply, what they're supposed to do. And when we talk about future regulation or creating a framework, then this is becoming even, I would say, a more challenging issue. Thank you.
Okay, great. So thank you all four speakers. We still have a few minutes. I mean, I wonder whether anyone wants to take the floor and from the audience and pose a question. Dana?
Thank you. It was a very interesting talk. I'm wondering about the business model of these private companies where they provide the service, but the so-called operation is not their responsibility. And I think this gap creates ethical problems. And I'm aware that with weapons, this is the case. Weapon manufacturers sell their weapons and their responsibility. I'm wondering if this same structure of regulation should be adopted as is. And when we speak about software, which is, I assume, gets debugged over the time, and there is some back and forth and updates of versions. And on this regard, I find it different. And I believe that if the private companies, which I do see a black hole in the regulation of it, it's not clear under international law what are their obligations for human rights, or that is. So whether that can be a game changer in regulation, having private companies also responsible for the operation of the softwares.
Can I take that one?
Maybe we'll collect just a second. If there are other questions, we'll take one or two more, and then we'll go back to the panel if there are any more questions. Yes, Yuval. Hi.
Thank you very much, first of all, for this very great roundtable, and I'm very happy to be able to participate in this and get an insight on this subject. I wanted to ask, as a kind of follow-up question to Dana, Dana Yaffe, regarding business and or human rights obligations of perhaps bigger corporations, because it struck me that, and it's definitely true, what Mr. Reisner was saying, that it's no longer true that the best capabilities exist within the government, and that actually corporations are much more getting much better in creating these technologies. And when we think about states, they do have obligations, human rights obligations specifically. And if there is an incident where a state has perhaps done something or created a technology that could violate human rights, then this state could be held responsible under certain mechanisms. So the question is, if these companies actually now have these bigger capabilities and even better, stronger mechanisms, whether that, I mean, this is a very provocative question, but shouldn't those companies then also have these obligations that states already have? This kind of goes into the direction that Dana has already asked it.
Great, thank you, Isabella. One final question, and then we return to our speakers. Does anyone wish to take the final question? Going once, going twice. Okay, so Shmuel, let's hear you, and then if the others want to chime in, they can.
So first of all, relating to Dana's question, the amount of times that we've been requested or offered, I don't even want to talk about the astronomical amount of numbers by customers to operate the systems on their behalf in type of like a BOT type of arrangement. Would be, commercially, financially, it would put us in a totally different sphere. And you talk about, maybe on the ethical side, the fact that we are not, privy to the data, it has its restrictions, etc. But yeah, we believe and truly believe, and I'm sure that Daniel can also add the international law aspects of a private company being an active part of warfare, or not even warfare, of intelligence gathering, the meaning of it. On the ethical side, we totally believe that our position is as a software provider. Of course, when you provide software, you need to go and provide certain support and certain upgrades, but this is all done in a closed box type of environment without the customer having the actual source code, or for as far as the customer is concerned, it's a black box, taking into consideration all the concerns. Some of them Daniel kind of talked about having a misuse by a government employee, etc. The irony that Daniel mentioned as far as us, the private company, being trying to be the responsible adult vis-a-vis a government. But I think that the alternative of having us operate systems is something that I think is unmanageable for many reasons. And to Isabella's question, I think that what we've been discussing, and as part of the programs that we're putting into place, I think that the main premise is that yes, we do see some type of responsibility. Our guiding guidelines. I didn't mention this, is basically most of our program is based on the Human Nations Guiding Principles for Business and Human Rights, which basically has two chapters. One is the government's responsibility for protecting human rights, and the second one is for the corporate responsibility. Whereas if you read the document and as a whole, you see that the corporate responsibility, it's more it's more intended for the supply chain. Talk to the people that were drafting it, and part of them are consultants as well. Under the supply chain, child labor, the classic sneaker factories of 12-year-olds, wherever they may be, conflict minerals, et cetera, et cetera. It doesn't really relate per se to the fact of providers of software by private industry to governments, yet the linkage is there, and we are taking the let's call it less lenient interpretation of the UNGP. And we do believe that we have a responsibility. The primary responsibility lays with the government, but we do see the linkage, and we do see ourselves responsible toward the responsibility. And that is really the premise of why we put all of this ethical programs and compliance in place, because otherwise, if we could just say, you know, we're software providers, and, you know, Microsoft or any other company just, you know, gives a license and signs off on the terms, and that's fine. That's the road that we are not willing to take, because we do see the responsibility of our powerful tools towards the misuse, and, you know, that's why we are doing what we're doing.
Does anyone else want to? Ken, Daniel.
Yeah, Dana, to add to what Shmuel said, just to clarify, no government will allow a private company to operate such a system for another government. There's no way ever to get a license for such activity, because that would make you the equivalent of a cyber mercenary. And so the government's prohibited. They say you can sell the system, but you cannot be involved in the operation. It's one of the basic principles of all the licenses in this field. So it runs exactly against what you said. Isabella, to your question, you actually touch upon a bigger question. When we, the world, not we, us, set up the modern structure, you know, Yuval, when we are international law practitioners, we take it back to the 17th century, to the Westphalian system. We set up the new country system of 1648, and international law developed for those countries because they were developed hand in hand. We did not anticipate a world where actually countries are in some areas less important than corporations. So today in our modern world, companies like Facebook and Microsoft and Walmart and Amazon are much more powerful than 50% of all the countries in the world. And I give lectures just on this. And yet the international law we develop only applies to the countries, not to the company. And everything else is soft law. You can adopt it, its principles, its guidelines, it's not binding, it has no enforcement, it has nothing. Now, I think here we have a totally disassociation between the law and the reality. I think once we realize that multinational players are significant actors on the world stage, at least equivalent to some countries, we need to find a way to take some of the basic principles and apply them aggressively to them, not voluntarily to them. And this is just one very small and actually relatively unimportant example of much bigger things. So in my eyes, you are touching upon a very important hole in international law, that it does not apply directly to these big players. And you are right, in this area as well, there could be legitimacy to come and say you are part of the chain, the causal link or whatever, if there's a violation. The same you could say for manufacturers of weapons or anything else. International law just doesn't do that. And this is one of the areas where there are people looking at it and saying we should expand international law to cover it, but it has not happened yet. And there are lots of reasons why it is not happening. So the short answer to your question is international law is not there, but I am personally not against the idea that it should try to expand into that area more than it's doing right now.
Okay, thank you, Daniel. Ron, do you want to say something, or we close?
I think it's not in my domain, the question, so I will pass.
Okay. So I want to thank again all the four speakers for very lively and informative exchange. I also want to thank all participants for following us. I want to thank Tal for putting this together and wish us all a very good and safe and quiet evening. Tehilla wrote, may we have the quieter times, and I join her in this wish. Bye-bye.
Bye-bye. Thank you.